I'm Catherine Park. I'm an immigration attorney in the United States. Immigration violations are civil sanctions for the most part, not criminal sanctions. Now, there are types of immigration misconduct that can be charged as a crime. For example, document fraud could be punished criminally or civilly, but more often the violator is just removed from the United States. That's a civil sanction. And we usually associate detention or incarceration with punishment for criminal violations. So how is detention justified for civil immigration violations? I'll discuss that in this video, along with recent developments regarding the Department of Homeland Security's practices in detaining alleged immigration violators. There's a debate raging right now between the border states and the federal government regarding the types of immigration violations that justify incarceration before removal. The debate is also about who makes the detention decision, and at what point in the process of investigation or prosecution can the individual be detained. Well, he can be detained at any point in the process, not that he will be detained, but that he can be. And that's actually consistent with how the criminal laws operate. So, although immigration sanctions are civil sanctions, the issue of detention under the immigration laws is treated more like criminal detention. For instance, let's say a U.S. citizen is stopped on suspicion of DUI or DWI. The police officer can take the individual into custody rather than just issuing a citation with a court date. The individual will have a bail hearing, sometimes called a bond hearing. If the defendant doesn't post bail or bond or doesn't comply with some type of non-financial conditions of release, the person could be taken into custody again. Although under the federal standards, the Bail Reform Act of 1984, detention before trial is supposed to be ordered only to prevent flight from prosecution or to prevent danger to the community. Now, a lot of advocates say, well, isn't preventive detention just a guessing game? How can you predict what a person might do while they're on release? So it is a guessing game to some extent. There are real-world examples of people who were released on bail and went on to commit murder while they were on release. We've heard about those cases. So those individuals, by their actions, have cemented the law of preventive detention for everybody else. Pretrial detention, preventive detention, is common enough in the criminal law. And there are many, many, many criminal cases in process compared to the number of immigration cases in process. I'm referring to removal proceedings. Now, in some state courts, even misdemeanor defendants are detained before trial. And you could say that's an example of over-incarceration. And that might well be in many misdemeanor cases. But what if the misdemeanor is DUI? Let's take our example. A non-aggravated DUI, DWI, is usually a misdemeanor, but it has the potential to take innocent lives. And there are plenty of examples of immigration violators who are arrested and convicted of non-aggravated DUI. And that includes no contest pleas, where the defendant doesn't remember what happened because he was drunk, but he admits to the essential facts of the misdemeanor in a no contest plea in exchange for a reduced sentence. Now, DUI, DWI is defined differently in every state, but the immigration authorities say that's not going to stop us from removing you, okay? So they could take a more conservative approach than the state law. According to the federal government, the statute, the Immigration and Nationality Act, plays a role in defining the offense because waivers are available under the INA. And also, maybe the state's criminal law wouldn't charge you for an action that shows you have bad moral character from the perspective of U.S. immigration. But the federal government determines, even if the state would allow you to walk free, we think you're deportable. So a criminal conviction under a state's law could be over-inclusive or under-inclusive for purposes of U.S. immigration. As an example, what if the person pled guilty to avoid a disastrous trial in the state court because during jury selection, the judge allowed a person to be seated who was unwilling to follow the law? Now, the judge disagreed with you about that and seated the person anyway. And so the defendant wants to change his plea. He wants to plead guilty and not go to trial. And the judge is like, yeah, okay, I'll let you plead guilty. Those types of structural defects in the trial should not determine the fate of non-citizens as to their rights under federal immigration law. There have been so many lawsuits directed at the federal immigration authorities when they decide not to detain an immigration violator. That type of lawsuit reached the U.S. Supreme Court last year. The state of Texas filed the suit. One of the issues in the lawsuit brings me to my next point that I mentioned. Who decides which immigration violators or alleged violators will be detained? Is it the federal government or the states? Now, each sovereign has its own jurisdiction. The federal government is authorized by the immigration statute, the Immigration and Nationality Act, to set priorities for enforcement, including detention. The Secretary of the Department of Homeland Security has statutory mandates to establish national immigration enforcement policies and priorities. Now, the controversy arose after Secretary Mayorkas of Homeland Security, DHS, issued a memo setting priorities for civil immigration enforcement. And Texas, joined by several states that filed amicus briefs at the U.S. Supreme Court, assert that the memo indicates DHS is allegedly abandoning its responsibility as set forth in the Immigration and Nationality Act, Section 236C, to take into custody certain criminal non-citizens awaiting removal. But that's not what the memo says. So let's look at the INA Section 236C. According to this subsection, the federal government has to take into custody non-citizens who are convicted of enumerated crimes, which include violent crimes, crimes of moral turpitude, such as document fraud, certain firearms offenses, national security offenses, sex crimes, drug crimes, etc. These are all deportable offenses. Deportation is a civil sanction, but the non-citizens could also be criminally prosecuted for the offenses. So after a non-citizen is criminally convicted, the statute says take them into custody to await a removal hearing. Okay, that's a civil sanction. It's about preventive detention to await removal. The state of Texas and the amici, the border states, are asking the court to strike down the action of the DHS secretary in conducting a more incisive analysis of what constitutes a criminal conviction for purposes of INA Section 236C. Preliminarily, if non-citizens are convicted of those types of crimes, they will be prioritized for removal. That's not even in question. If a non-citizen is a danger to society or a flight risk, they will be detained in the federal criminal system or the federal immigration system, and then they will be removed. The bottleneck could be the state side of things, because the state trial could have had defects that render the alleged conviction not a conviction for immigration purposes under Section 236C. There's so much variance in each state's criminal trial court practices that the immigration authorities are justified in saying it's not right to detain all of these non-citizens just because the states have deemed them to be convicts. We need to do our immigration analysis to determine if the state's process produced a conviction for purposes of Section 236C. Also, the federal regulation says when those individuals are taken into immigration custody, they will be ineligible for release except in very exceptional circumstances, such as they were a victim of trafficking who acted in self-defense to escape the abuser, and the abuser pressed charges for criminal assault. No surprise. Or maybe a non-citizen cannot be removed because there's no record of their existence in their home country, so they cannot be issued a passport. And if that's the case, how long can those folks be detained? Well, if they refuse to cooperate in obtaining travel documents, and that's the reason why they remain detained, they refuse to return home, essentially, the federal courts have suggested that they can be detained indefinitely.